Good morning. It is approximately 9 a.m. on June the 5th. This is the first docket of the month. It is the hearing by affidavit docket. However, some of the cases have been objected to at the last minute, and we will deal with those first as status conferences. So the first two cases I am going to call are the Oxy USA cases. That is 25222 and 25225. Answers of appearance, please.
Good morning, Mr. Hearing Examiner Paula Vance with the Santa Fe office of Holland and Hart on behalf of the applicant Oxy.
Thank you.
Good morning, Mr. Examiner. Dana Hardy with Hardy McLean on behalf of COG Operating.
Good morning, Mr. Examiner. Jennifer Bradfute with Bradfute Sayer on behalf of EOG Resources.
You said EOG?
Yes.
Thank you. And are those all the parties, Ms. Vance, that you know of?
That's correct.
All right, thank you. Let me go to Ms. Hardy first, and then I'll come back to you, Ms. Vance. Ms. Hardy, did you object?
Yes, I believe that we did, and I think we've worked out an agreement with Oxy. So it's my understanding that Oxy is agreeing to amend its application, and
We'll get to you in a minute, Ms. Vance. So hold on, let me just finish with Ms. Hardy. Ms. Hardy, did you enter an objection in writing in this case?
Yes.
I don't know that we actually,
Because I wasn't aware you did.
then maybe we didn't actually object.
I'll wait.
You did.
You know. Okay, I don't believe we objected.
I didn't think you did. But you entered an appearance in the case.
Yes.
Okay. And you're saying now that you're, if you were going to object, that reason is no longer there.
Well, I think that Oxy has agreed to certain conditions in its order. So if they had not entered into that agreement,
Okay.
then we would object.
I see. Okay, very
So,
good. I
yes.
understand. Okay, very good. And Ms. Bradfute?
EOG also agreed to the conditions, so Oxy is going to put in those conditions into its exhibits, which I believe it's already done, and then we want the order to reflect the conditions.
You want the order to reflect the conditions. I'm not sure that the division works that yet.
There are certain items that are different from the application, so the items that were stated in the application are going to be changed in the
Okay.
exhibits, and all the parties have stipulated to that.
Okay, that makes more sense now.
Yes.
Okay, Ms. Vance.
Yes, that's all correct. We have agreement on certain conditions and plan to go to hearing and provide testimony that reflects that and requests that those conditions appear in the order.
That makes sense. Okay. So when are we going to receive? Well, so you said, it's my understanding from Ms. Hardy and Ms. Bradfute that you're going to amend your application?
We do not plan to amend our application. We'd like to move forward as is, but we'll request that the conditions are included in the order.
Okay. Ms. Hardy?
That is correct. I believe that they are basically amending what they've asked for in the application through their hearing exhibits. I believe that's the plan.
Okay. Are you going to participate at the hearing, Ms. Hardy?
We would enter an appearance, we would maintain our appearance and monitor the case, but we would not plan to present evidence.
But you'll be there for cross-examination if necessary?
If necessary, yes. Although I wouldn't expect we would have cross-examination as long as the conditions that we've agreed to are included in their proposal.
And Ms. Bradfute?
Same.
Same. Okay. Ms. Vance, when do you want this case to be heard?
We would like to request either July 24th or August 7th.
Okay. And I didn't know about those dates. Have those been offered already?
No, but that's when I have witness availability. I came prepared.
Ms. Chance?
Ms. Bradfute?
No, Ms. Chance. I'm not asking you, Ms. Bradfute.
Thank
I'm
you.
asking you, Chance.
We could do July 10th, or I think it's August 7th.
That's what I thought. We don't have July 24 as a possible date.
Okay, can we do the August 7th then?
I don't see why not. Ms. Chance, is that open?
Yes,
Would that be a trailing?
that is our hearing by affidavit docket. So
I don't want to have this on,
Okay.
on a hearing by affidavit doc. I want to have this separately, either as a special. We have if everyone could turn off their microphones on their laptops, it'd be helpful. So Ms. Vance, I don't want to hear this on a day where we have regular docket. I want to hear this on a trailing docket or on its own. So Ms. Chance, what dockets do we have? You asked for what dates, Ms. Vance?
The other date was July 24th.
But what was the first date?
It was July 24th and August 7th. But if it's not August 7th, if you could provide some dates, I can confer with my client and confirm when we would have witness availability.
Okay. Are you looking for end of July, beginning of August? Is that what you're looking for?
Yes.
Ms. Vance? Ms. Chance?
We could do it July 15th. I don't know if that's too early. That would be a trailing docket, or Tuesday, August 12th.
Perfect. How are those 2 days?
I will email my client right now and
Perfect.
see if I can get an answer by the end of the hearing.
And then we'll issue a pre-hearing order to get that. Okay, perfect. Taken care of. Anything further, Ms. Vance?
No.
Any other party? All right, thank you. All right, we're off the record in these 2 cases. We're going to hear some cases that were objected to last minute. These are cases that were numbers 24 through 28 on our docket. They are Matador Production Companies 25388, 90, 91, 93, and 25409. Entries of appearance, please.
Good morning, Mr. Hearing Examiner. Paula Vance with the Santa Fe office of Holland and Hart on behalf of the applicant Matador.
Thank you.
Good morning, Mr. Examiner. Scott Morgan with Cavan and Morgan on behalf of Wyotex Drilling, Jaeger Resources, the Patsy Hinchy Family Limited, Seven Way Minerals, the Carol Ann Sandquist 1995 Management Trust, Blessed Income LLC, Mary Helen Energy LLC, Pops Minerals, and McCrae Management Trust.
Perfect. Mr. Morgan, I have your document that you filed. That's not date stamped, but I suspect you filed it yesterday. Respondent's motion for continuance. I don't believe that you are a respondent. So in the future, don't use the respondent because that doesn't quite suit in this case. But I've had a chance to review it. What I understand from your motion is the following: that you or Wyotex acquired leases from Thomas Alexander on April 30, 2025, but that were recorded on May 12, 2025. That you notified MRC Permian of the new address and interest via phone and email on May 12 and again on May 15. Despite this, MRC served notice at an outdated address. So you're saying Wyotex was not properly served. Do I have that correct so far?
Yes, correct so far. And that's just in 2 of the cases, and then a separate, and I'm sure you're going to get to it, that separate motion in the other 2 cases on behalf of the other parties. Yes.
I see. Okay, very good. So let me continue then. So then you cite one of the rules that a party is entitled to a continuance if it did not receive timely notice at least 3 business days before appearance deadline. And you cite another rule saying that the motion was timely filed because Wyotex only became aware of the proceedings on June 2nd. How did you become aware of the proceedings on June 2nd?
So I became aware. So Wyotex, and we'll separate them from the other parties for just a minute. Wyotex called me. I don't know exactly what the discussions had been between Wyotex and these other parties. I don't have that in front of me. But I believe what happened is that some of these smaller parties in some of these cases that are being heard today, somebody heard something. I honestly don't know if somebody got a call, if somebody said, we thought maybe something was going on. But then they started having their round robin telephone calls. And that's when I started to receive calls Monday afternoon and then Tuesday morning from most of my clients at that point.
Okay. Then you also say that, or that you assert that publication is insufficient where direct notice is possible. MRC allegedly failed to make good faith effort to negotiate voluntary pooling and communicate meaningfully with Wyotex. And you argue that you've been prejudiced and granting continuance would not prejudice MRC, et cetera, et cetera. Okay, so do I have the basis for the objection? And you're saying that's because your motion is captioned in all 5 cases, but you're saying this motion is not directed at all 5 cases?
It's not. Because of the cases were consolidated in
Yes.
the other pleadings that were filed by Matador, we just wanted to keep that same caption so as not to confuse anybody and to make sure they appeared properly.
So then this is just for 25388 and 25390, is that right?
Correct.
All right, so in these 2 cases then, let me turn to Ms. Vance. Ms. Vance,
Yes.
your response?
I mean, one, we provide notice based on what was last noted in the county records. So as far as I understand, that's where the notice went. However, if there is an objection, we'd like to just go ahead and set a contested hearing date. We don't want to delay these and don't really feel like we need to have obviously, we'll have a status conference per the pre-hearing order if we need to, but we'd like to just go ahead and set a contested hearing.
All right. So, Mr. Morgan, I'm looking at the rule here. And the rule that I'm looking at right now, 1915-412A1. Are you familiar with that rule?
I believe that I am, and I apologize. I had travel scheduled for today, and I'm actually in the midst of traveling, so I don't have my laptop up in
No
front of me,
worries.
so I can't pull it up. I apologize.
Okay, we'll accommodate you. I understand. You do cite to the rule in your motion. You cite to part of the rule in your motion, so I'm assuming you must be familiar with the rule because you cited to Part 10, subsection D. I'm now reading from 12A, and it says 12A1. The applicant shall give notice to each owner of an interest in the mineral estate of any portion of the lands the applicant proposes to be pooled or unitized, whose interest is evidenced by a written conveyance document, either of record or known to the applicant at the time the applicant filed the application. And then it goes on, but that's the critical phrase, is at the time the applicant filed the application. So, that being said, I understand that you have acquired interest. Are you arguing here that notice is so? Are you just asking for a continuance, or are you arguing here that this application needs to be dismissed and refiled to give proper notice?
Primarily, we are asking for a continuance so
Okay.
we have some time to really review.
Okay, perfect. Okay. And Ms. Vance is asking for a contested hearing to be set. So let's talk about that for a moment. What do you anticipate your participation in a contested hearing to be? Do you anticipate that you're going to want to bring evidence of your own, or is this just a continuance for you to negotiate with the applicant?
So my client in these particular cases has been attempting to get some additional information on the drilling of these wells. I anticipate that my client has told me they plan to participate, but they need additional information to be able to evaluate that participation. My hope is that they would be able to agree and then participate. They just need that additional information so they can evaluate.
Okay, so you filed a motion for a continuance. I know you filed an entry of appearance as well. I'm limited to what I can see. I only have 2 screens here. Was your entry of appearance, was it also an objection?
It was.
Okay.
And again, that comes primarily from the no meaningful discussions to
Yes.
Yeah.
I understand. So then are you anticipating maintaining that objection so that you force this to a contested hearing, or are you anticipating that once your clients get additional information from the applicant that you withdraw your objection?
I anticipate that that information will be forthcoming, and that at that time we will probably withdraw. Yes.
Okay, all right, okay. All right, so Ms. Vance, first of all, I'm not sure why these cases were joined the way they were anyway. I'm not sure you asked for them to be joined, did you?
Yes,
Oh, you did?
yes.
Oh,
For these,
when did you do that?
because these are all a part of the same development.
Okay.
So off the top of my head, the Ed Drake, I believe, are the Bone Spring, and then the Steve Rochelle is the Wolf Camp application.
So you then requested these to be joined. When did you request them to be joined?
Well, I filed a consolidated pre-hearing order,
You did?
or a consolidated pre-hearing statement, rather. Sorry.
I understand. I didn't understand that. Thank you very much.
Mhm.
Okay. So Ms. Vance, you said you'd like to set these for a contested hearing, knowing that the objection may go away. We can issue a pre-hearing order that says these are set for a contested hearing, and if the objection is withdrawn, we'll hear them at the next hearing by affidavit docket.
That works for us.
It does. Okay.
Mhm.
What time frame are you looking at?
I mean, we would like to be on the first available contested hearing date, but understand that probably Mr. Morgan would like that at least a month out. So if we have something next month, that would be fine.
In July.
In July, if
All right.
possible.
Okay. Mr. Morgan?
I think that would be perfect, and I appreciate Ms. Vance's consideration there.
All right. Sounds good. Ms. Chance, what do we have in July?
July 15th.
July 15th. You'll
That
check
works.
with your witnesses?
Yes, let me just check with
Of
them
course.
and then I'll respond by the end of the hearing.
All right, well, I'm going to put down here that we've offered you July 15. And unless we hear differently, we'll set a pre-hearing order for July 15th. Which will then also mention the first August date for hearing by affidavit, if in fact the objections are withdrawn. Okay, so Mr. Morgan, you said you filed a similar motion in 3 other cases. I did not look at those yet. There wasn't time this morning to look at those. So let me, can you tell me one of the case numbers that you filed that other document in?
Absolutely. It would be 25391.
Let me get there. Okay, got it. Okay. Respondents motion for a continuance, and these are for Jaeger and the other parties that you are representing.
Exactly, Mr. Examiner.
All right. Let's see. Now, since I don't have time I don't want to waste time reading this whole thing here. First of all, what are you asking for and what's the basis of your request?
Very similar, Mr. Examiner. In this particular case, with respect to these parties specifically, the correct addresses were actually of record more than 6 months ago. There had been some assignments that were made in December, and the hearing exhibits that were filed reflect the prior parties as still owning it, and so notice was given to the prior owners who had owned it prior to 6 months ago. And again, phone tree, people started calling each other, hey, have you heard something's going on, etc. And so these particular individuals called me yesterday, asked me to take a look at this, look this up. And so it looks like a number of these parties, their correct addresses should have been on record from 2 years ago to up to 6 months ago. And it was prior parties that were given no. So effectively the same. I anticipate that given some time to review the application, the information regarding the operations, that we will more likely than not ultimately withdraw the objection, and this could probably move forward by affidavit in August as well.
Okay, so what I'm hearing,
opportunity to review.
so what I'm hearing from you is it's very similar. Your clients did not receive notice as you would have hoped, and they want a little time to look at this. You maintain your objection. You did file an objection in this case, these cases as well?
We did, Mr. Examiner, yes.
All right, sounds good. So if we include these cases in the same pre-hearing order, setting it for July 15, that gives you enough time to either withdraw your objection or proceed to hearing?
100%, Mr. Examiner. Thank you.
Excellent. Ms. Vance?
That works for us, and I do want to ask one question. So it sounds like Mr. Morgan's clients are not objecting to 25409. I was a little confused because I did see the entry of appearance and objection, and that was also in the caption there. And if possible, if they are not objecting, we would like to
Okay.
move forward with that case today.
Sure.
And happy to get my experts on the phone if the hearing examiner wouldn't mind moving that to the bottom.
I don't mind.
So
Mr. Morgan, you're not objecting to 09?
We are not objecting to 09.
Perfect. Then we'll hear that by affidavit at the end of our docket.
thank you.
All right, you're welcome. Okay, so unless I hear differently, we're going to issue a pre-hearing order setting these 4 cases, 88, 90, 91, and 93, for a contested hearing on a trailing docket July 15. If the objections are withdrawn from your clients, Mr. Morgan, then we will hear this by affidavit in early August. Is there anything further on these cases?
No.
Nothing for me, Mr. Examiner. I appreciate your
Perfect.
consideration today, Ms. Vance. Thank you so much.
Thank you, Mr. Morgan. Going back to our regular docket. We are calling number 3 on the regular docket. This is ConocoPhillips 25313. Entries of appearance, please.
Good morning, Mr. Examiner. Dana Hardy with Hardy McLean on behalf of ConocoPhillips Company. And there are no other parties.
Perfect. Please proceed.
Thank you. In this case, ConocoPhillips seeks an order pooling uncommitted interest in the Bone Spring Formation underlying a 1,920 acre, more or less non-standard horizontal spacing unit comprised of all of sections 27, 28, and 29, Township 23 South, Range 30 East in Eddy County. The unit will be dedicated to the Iron Throne Federal Com 501H through 505H wells. We've provided with our exhibits the self-affirmed statement of land professional Macy Valles and geologist Shariva Darmayon, both of whom have previously testified before the division and been recognized as experts in their respective fields. Ms. Valles provides the standard land exhibits. The tract ownership and pooled parties are identified in Exhibit A3. Exhibit A4 is the non-standard spacing unit map that shows the interest in the surrounding tracts, who all did receive notice of this application. Mr. Mayone provides the standard geology exhibits. Exhibit C is our notice information. Notice was timely sent by certified mail on April 17th, 2025, and was timely published on April 22nd, 2025. So with that, unless there are questions, I request that our exhibits be admitted into the record and that the case be taken under advisement.
Okay, the objection, so there's no objection to the exhibits. They're admitted without objection. Are there any questions, Mr. Fordyce or Mr. McClure? I'm not sure who's the examiner on this case.
I will be Mr. Hearing Examiner, and I do have questions for the geologist.
All right, perfect. Let's get the geologist sworn in. And while we're doing that, I'm a little confused. I need to go back to 25409. Ms. Vance, I am looking in that imaging system, and I see an entry of appearance and notice of objection to proceeding by affidavit filed by Mr. Morgan. Now, Mr. Morgan just said he's not objecting to that case, but yet he filed this objection in this case. So, Ms. Chance, can you communicate with Mr. Morgan to get a written withdrawal of objection filed in this case in the next, 30 minutes or so we can proceed? I know we have his oral statement saying no objection, but here it is. I'm looking at it.
I think, and that relates to the fact that I filed the pre-hearing statement with all of the applications consolidated. So just based on what he was saying, it sounded like he put them all together because I was requesting to consolidate the cases.
I understand perfectly. But I do want a withdrawal of objection, Ms. Chance. Thank you. Okay, do we have the, it looks like we do. Can we, yeah, thank you. Would you state and spell your name for the record, please?
Good morning. I'm the geologist from ConocoPhillips. My name is Shariva Darmayon.
And you're going to spell your name.
First name Shariva, last name Darmaon.
Thank you. Would you raise your right hand, please? Do you swear or affirm under penalty of perjury that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
Okay. And you said that you are an expert in the field of petroleum geology.
That's correct.
Okay. Have you been accepted as such by this division?
Yes, I was last year.
Perfect. Mr. McClure.
Thank you, Mr. Hearing Examiner. Miss Domenon, can I draw your attention to your cross section in Exhibit B4? That's on
Yes.
page 46 of 115 in the exhibit packet.
Yes,
Mr.
I have
McClure,
it in front of me.
hold on one second. Ms. Vance, no, Ms. Hardy, would you share your screen?
Yes,
Thank you.
let me pull that up.
I just want to see it too, Mr. McClure. Thank you.
Do we have the API numbers for these 3 wells included anywhere in the exhibit packet?
They are not. How would you like me to provide them?
Typically, we just include them on this cross section itself, like right below the well name, or right above it, or at the bottom of the log, something like that. Just some sort of identification beyond merely the well name.
Okay, I can look those up. How would you like me to submit those in the chat or just verbally state those? I would have to look them up.
What we'll want is we'll want an amended exhibit packet.
Okay.
But I mean, just to confirm, you understand what I'm asking for here, I guess.
Yes, I do.
Okay, thank you. Yeah, I was going to say your Miss Hardy will deal with the actual filing. She'll work with you on that.
Okay. Then.
Mr. Hearing Examiner, I did have some additional guidance for Miss Hardy on this case in regards to pools.
Okay, perfect. Go right ahead.
Okay, Miss Hardy, you have the correct pool for most of it. Let me scroll up to your C102. But the southwest quarter of section 29 is a different pool. Do you have are you prepared to take a pool name and pool code, Miss Hardy?
Yes, thank you.
Okay, well, it's a Wildcat, then some numbers, Lower Bone Spring. The pool code is 97753.
Thank you, Mr. McClure. So would you like us to include C102s that include that pool name and code along with the current C102s?
Yes, ma'am. We'll need to correct our CPAC to include both the pools and then the appropriate C102s. New C102s for the existing pool that exclude that southwest quarter, and then another C102 for the new pool.
Understood. We will get that submitted.
And in addition to that, of course, the discussion I was just having in regards to the geologist exhibit.
Understood.
Ms. Hardy, how long will it take for you to submit that?
I would need to check with my client about obtaining the C102s. I think probably next Thursday would
I
work.
don't want to leave the record open that long. If it's something you can correct by tomorrow, close of business, we'll leave the record open. Otherwise, we'll continue the case to the next hearing. So it's up to you. How long will it take?
Well, I think we can plan to get them submitted tomorrow by the end of the day. And if that's a
Perfect.
problem, then I'll advise the division.
I'm willing to leave the record open until close of business on the 6th of June for these minor corrections. But if they can't be complied with by then the case will be continued by yourself to the next docket, to the next hearing by affidavit docket, which will be in July. Is there anything further on this case?
No, thank
No.
you.
All right, Mr. McClure, are we done with the questions?
Yes, Mr. Hearing Examiner.
All right, thank you. Let's take a 5-minute break and we'll come back on the record. Thank you.
You're still sharing your screen, by the way.
Yeah, somebody's still sharing her screen.
It is 9:32 a.m. We are back on the record. We are going to hear case number 4. This is Tap Rock Operating 25315. Entry of appearance, please.
Good morning, Mr. Examiner. Miguel Suazo with Beatty & Wozniak appearing today on behalf of the applicant, Tap Rock Operating.
Thank you.
Good morning, Mr. Hearing Examiner. Paula Vance with the Santa Fe office of Holland and Hart on behalf of COG and Concho.
Thank you. Mr. Holliday. Mr. Suazo, do you know if Mr. Holliday withdrew his entry of appearance?
Not to my knowledge, but if it helps, it's really not material, I don't think, just because unfortunately, I learned late last night from the client that they would like to request a continuance. They learned about some contractual matters
Okay.
that could impact one of the sections in the application. And so out of an abundance of caution, they'd like to respectfully request that they continue this case to August 7th if it's still available.
It is. We're happy to do that for you. So you'll continue this case to August 7th.
Yes, we'll file a formal motion by the end of the day.
Okay. Okay, thank you. So we're off the record in this case.
Thank you.
Thank you. Moving on to number 5 on the docket, 25325. This is Permian Resources.
Good morning, Jackie McLean with Hardy McLean on behalf of Permian Resources.
Good morning. Are there any other?
Yes, Mr. Examiner. Good
There-
morning. Carrie Hatley entering an appearance on behalf of COG Operating, monitoring only.
Perfect, thank you. All right, Ms. McLean, go right ahead.
Thank you. In case number 25325, Permian Resources seeks an order pulling all uncommitted interests in the third Bone Spring interval of the Bone Spring Formation, underlying a 480-acre, more or less, standard horizontal spacing unit comprised of the south half, north half of Section 15 and the north half of Section 16, Township 20 South, Range 28 East in Eddy County. And the unit will be dedicated to the Foster 1615 FedCom 132HJ turn well. Permian Resources submitted a timely exhibit packet for this case, which includes land testimony and corresponding exhibits from Ryan Curry and geology testimony and exhibits from Christopher Canton, both of whom have previously testified before the division as experts in their respective fields. Permian Resources also submitted notice exhibits, which include a copy of the notice letter that was sent out on April 17th and an affidavit of publication, which shows notice was published on April 22nd, 2025. And with that, unless there are questions, I ask that the exhibits submitted for case number 25325 be admitted into the record and that the case be taken under advisement.
Thank you, Ms. McLean. Without objection, your exhibits are admitted into evidence. I'm just going to mention that in the past, I've asked if there is objections, and not hearing any, then I admit the exhibits, but I'm depending on parties to be prompt and to pay attention. So if I don't hear an objection when exhibits are offered into evidence, I'll just say without objection from here on in. Mr. McClure, are there any questions for Ms. McLean's witnesses in this case?
Yes, I do, Mr. Hearing Examiner, for the landman.
Ms. McLean?
Okay, so Mr. Curry should be on.
Hello, yes, I should be unmuted now.
I don't see you yet. I'm hoping to see you.
I'm on the telephone. I don't have video capabilities right now.
Okay, well, when can you get to a computer to turn on your video?
Let me see if the Wi-Fi is working. Give me 30 seconds.
By all means.
Mr. McClure, are you going to want me to pull up any exhibits?
I mean, I'm going to be referencing parts, so I guess a guy could.
Okay.
All right, I have my camera on now.
Although I guess with you sharing, I'm not sure if our hearing examiner is going to be able to see your
Yeah.
witness, though.
I'll stop for now.
Is it Mr. Crosby?
Mr. Curry.
Curry.
Brian Curry.
Thank you. Thank you. Mr. Curry?
Yes.
Okay. We don't see you, so maybe you have something, maybe the slider on your laptop is needs to be moved to one side or the other?
I can see him.
You can. Where do you see him?
Yes. On my
There he
screen.
is. Now I see. Now I see. Okay, we had something else going on here. Okay. Okay, Mr. Curry, please raise your right hand. Do you swear or affirm under penalty of perjury that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
State and spell your name for the record.
Ryan Curry, RyanCurry.
You can put your hand down. You are an expert in what field?
Petroleum land.
Petroleum land. Okay, and you've been accepted as an expert by this division in the past?
I have.
Okay, Mr. McClure?
Thank you, Mr. Hearing Examiner. Mr. Curry, if I can direct your attention to paragraph 7 of your statement, your affidavit on page 5 of 45 of, oh, looks like Ms. McLean already has it there. Are you with me, sir?
Yes, I am. I'm looking at this paragraph 7.
Okay, and this paragraph 7 references the state CV number 1. Is that correct?
Yes, sir.
Okay, the death severance that is also referenced in this paragraph, is that in relation to that well?
Yes, it is.
Okay, can you please describe that depth severance for me?
Yeah, so this depth severance is from the base of the second bone spring to the base of the third bone spring interval. So it encompasses the third bone spring interval of the bone spring formation.
And was this due to something to do with this well causes the depth severance to occur right here?
No, sir. So there is a subsequent development plan that will not involve a J-turn. So we are pulling a subset of the bone spring formation so that we do not have overlapping pulling orders whenever we go back and develop the second bone spring interval here in should be less than a year. So we're trying to keep these pulling orders sole and separate for subsequent development.
Okay, but there's a difference in ownership above and below the base of the second bone spring. Is that correct?
There is a portion of this unit. So there is an existing second bone spring well in section 15 that does cause an ownership difference in the second bone spring versus the third bone spring.
And is that the state CV number 1, or are you just using the state CV number 1 as your type log, I guess?
That is just a type log. That is not the well. That is just to reference the stratigraphic equivalent as a type log. It is not the well causing the depth severance.
Okay, and what is the well causing the depth severance?
Give me 1 moment, please.
Yes, sir.
I believe that to be the government TCOM number 2, but I am somewhat uncertain as the ownership difference is a portion of the well. The reason we drilled the J-turn well was to not strand acreage in the north half, and the depth severance is created under a JOA that covers the development of a currently producing third bone spring well. And I believe the north half of section 15. But I believe it is the government TCOM.
Is the north half 15, is that the track that is not in this proposed unit?
Correct. That is the reason for the J-turn. It is not in the proposed units. But the JOA for that well and the depth severance is larger than just the spacing unit for that well, which encompasses some of the lands that we are drilling.
Okay, and do you know what all lands are covered in that depth severance then?
It should be all of section 15.
Okay, it should be, or it is all of section 15, I guess, for clarification.
I am fairly certain it is a JOA covering all of sections 15, but I would have to review the language in that JOA.
Well, is the JLA itself, wouldn't it be what causes the death severance? Correct? Isn't it some sort of selling of interest, something like that, that caused the difference in interest?
So it's a JOA attached to a farm out agreement where parties have the right to participate, and then I believe it's the second Bone Spring interval, and parties have the right on a well by well basis to elect to have a reversionary right. So when they elected to have the reversionary right in the first well that was drilled in the second Bone Spring, the interest in the second Bone Spring changed, but it also will subsequently change under the JOA if they elect to participate in the third Bone Spring. So it is not the mechanism is captured in the JOA farm out agreement, but it's not the direct. It's not all the JOA covers. It's just the mechanism for this reversionary right to participate is captured in subsequent articles of the JOA.
Okay, I understand. Essentially, it's the original lease agreement, and the JLA is the mechanism that's triggering that. Would that be accurate to say?
Yes.
Okay, thank you. And okay, sounds very good. And how that is situated is kind of on formation basis, is how you described to me, rather than like a direct TBD at any particular area. Is that correct?
Yes, that is correct.
Okay, thank you, sir. Moving on. Page 15 of 45, your exhibit A3. I think this is your summary of interest, I believe, spreadsheet here. Yeah, it looks like Ms. McLean has it. Are you with me, Mr. Curry?
Yes.
On this table, Dugan Production Corporation is listed as an unmarkable title. Can you provide me a little bit more details about what the nature is of their interest?
Yes, so they're the ones with the reversionary right that we just discussed. So Diamond Head Properties has the present interest, and then Dugan Production Company has the right to back into Diamond Head's interests, but they don't have a present interest until we drill the well and their election is made post-well. So they have a present interest in the fact that they could participate in the well, but they haven't been provided that opportunity yet. And this goes back to the second Bone Spring versus the third Bone Spring difference in ownership.
Okay, so the potential interest that they would get, is it included in this total breakdown here, just under a different name? Is that correct?
Yes, the unmarketable title represents that they have the ability to participate at their option, but Diamond Head and Dugan have not sent the elections to each other, so they have the ability to have a present working interest, but the election has not been made yet. Correct.
Okay, so if they were to have an interest, it would fall out of this 5.849 that you have attributed to Diamond Head Properties. Is that correct?
That is correct, yes.
Okay, thank you. If I can direct your attention to your summary of contacts page, Exhibit A5, page 23 of 45. Are you there with me, Mr. Curry? On your top item there on that table where you reference all parties, who are you referencing here?
So that would be all parties that are contained in my exhibit A3 as owning ownership in this project. So the parties that we are pulling and the parties that we are not pulling because we have reached a voluntary agreement.
Okay, thank you, Mr. Curry. Mr. Hearing Examiner, I have no more questions for the witness, but I do have guidance for Ms. McLean in regards to pools.
Okay.
Ms. McLean, if you happen to have a pen and paper handy.
I do.
Okay, the actual correct pool should be the old Millman Ranch semicolon BS. And the pool code on that is 48035.
Okay, the old Millman Ranch, semicolon BS, and then the pool code is 48035.
That is correct. So if we could just submit a amended exhibit packet with the CPAC and the Form C-102s, correct it.
And we can get that done definitely by end of day tomorrow. No problem.
Okay, thank you. We'll keep the record open on this case until 5 p.m. on the 6th of June for these corrections.
Okay, thank you.
Thank you. All right, let's move on to cases 6 and 7 on our docket. These are Marathon Oil Permian case numbers 25333, 25334. Entries of appearance, please.
Good morning, Mr. Hearing Examiner Paula Vance with the Santa Fe office of Holland and Hart on behalf of the applicant Marathon Oil, which was acquired by ConocoPhillips.
And I don't see any other parties entered in this case.
That's correct.
Please proceed.
Thank you, Mr. Hearing Examiner. Before I go through the exhibits, our landman, Ben Stecker, he has not previously appeared, so we have included his resume and he is available for questioning. So I would offer his resume for review and for him to answer any questions you have about his background.
Do we have him here now?
He is on. I saw him just a moment ago and I told him he'll need to. There he is.
There we go.
Mr. Stecker, there you go. Okay. Would you raise your right hand, please? Do you swear or affirm under penalty of perjury that the testimony you're about to give is the truth, the whole truth, and nothing but the truth? I guess he can't hear me.
Oh, no, you cut out for a minute there.
Okay, let me try again.
You're back.
Okay, let me try again. Do you swear or affirm under penalty of perjury that the testimony you're about to give is the truth, the whole truth, nothing but the truth?
Yes, sir, I do.
Okay, perfect. You can put your hand down. Would you state and spell your name for the record?
My name is Benjamin Stecker, Benjamin Stecker, Stecker.
Perfect. Let's go through your qualifications. What field of expertise are you seeking to be admitted as an expert before this division?
Petroleum land.
Petroleum land. Okay. Tell me about your education that goes toward that expertise.
So I have a 4-year degree in energy commerce from Texas Tech University. Then after graduating, I began work at ConocoPhillips in both Texas and New Mexico. In New Mexico specifically, I've had the opportunity to research leasehold ownership for Conoco, to interpret agreements and leases, manage obligations. And then in February of 2025, I obtained my registered professional landman certificate from the AAPL.
Okay. So when did you graduate with your four-year degree?
2022.
22. Okay. And if I understand you correctly, directly after graduation, you started working for the company you're working for now?
Yes, sir. I started at Conoco in June of 2022.
Okay. And what is your title with Conoco?
My title is land negotiator.
Land negotiator. Okay. From here on in, you are recognized as an expert in petroleum land. Ms. Vance?
Thank you. So I've requested to consolidate these cases.
Yes.
Okay. In both of these cases, we're requesting an extension on the order as well as pooling a couple of additional parties. The reason we are requesting the extension is because of that acquisition. There was a pause in drilling schedule, and so therefore we're here today to request that extension.
So the good cause is
the good cause is the acquisition and the pause in the drilling schedules.
And
oh, I'm sorry.
Since we're talking about good cause, is the landman familiar with the good cause?
Yes, and there's a paragraph, I think it's paragraph 6 in his testimony that goes to good cause.
Mr. Stecker, why don't you state on the record, what is the good cause for granting these extensions?
Yes, sir. After the acquisition of the Marathon, their drill schedule was put on hold because we have our own ConocoPhillips drill schedule that we still have to continue to maintain. So we took their projects that were preparing to go on their schedule and are finding places for them still. And are still making plans to move forward with them.
Okay, thank you.
Thank you. So we have included in our hearing packets a copy of the application, the original orders. Again, Mr. Stecker's statement along with his resume. We did include an updated pooling exhibit because we did have a couple of additional parties to pool because of a transfer of interests. We've included a sample of the well proposal letter and AFEs and a chronology of contacts. I do plan to file a updated chronology of contacts because I believe it was yesterday, Mr. Stecker provided an updated chronology of contacts because they reached one of the parties wishes to participate and sign the JOA. So we just want to make sure that's a part of the record. And then we've included my self-affirmed statement of notice. I believe it's mine. It might be Mr. Rankin's. But the notice went out on April 18th and the 25th, 2025. And then we've got the notice of publication, which was timely published on April 22nd and May 1st, 2025. Unless there's any questions, I would ask that the exhibits and sub-exhibits be admitted into the record and that these cases be taken under advisement pending any questions.
Okay, without objection. Mr. McClure, any questions?
I have no questions for either of these cases, Mr. Hearing Examiner.
All right. Ms. Vance, if you can meet the deadline by tomorrow to file that amended exhibit packet, we'll leave the record open until then.
It'll be done today.
Even better. All right. So I'm going to put down 5 p.m. as your deadline. Thank you, Mr. Stecker. Okay. We are off the record in these cases. Let's move on to 25338 Civitas Permian. Entry of appearance, please.
Good morning, Michael Rodriguez on behalf of the applicant Civitas Permian Operating LLC.
Mr. Rodriguez, before I hear from any other parties, this case relates to other cases, but it's not joined. Do you want me to call those cases at this time?
No, I think they should be handled separately unless Ms. Vance.
Okay, we'll keep it just as one case. Are there any other entries of appearance in this case?
Yes. Good morning, Mr. Hearing Examiner Paula Vance with the Santa Fe Office of Holland and Hart on behalf of MRC Hat Mesa. And I am representing COG, but in separate applications. I don't believe we actually filed an entry of appearance. Oh, we did. I'm sorry. My colleague might have done, Mr. Rankin must have done that while I was out. So yes, on behalf of MRC and COG. Thank you.
I don't believe that you did for COG.
Yeah, that's what I'm saying. You did.
Mr. Rodriguez?
I'm double checking now. That might be right. Yeah, I don't see it in the case record.
You don't see what in the case record?
I'm sorry, an entry of appearance for COG. I see that there is a continuance filed on behalf of the parties by COG, but there isn't an entry of appearance.
So then Ms. Vance is representing MRC, is that correct?
MRC, yes, but we are representing COG. I can file an entry of appearance, so it's on the record.
But verbally today, you're entering on for both.
Correct.
Okay, Mr. Rodriguez.
And for what it's worth, in both of these sets of cases, neither party is being pooled, and there's already been a voluntary agreement executed for both of those parties.
Okay. Are you presenting the case today, Mr. Rodriguez?
I will be.
Please proceed.
Thank you. So in this case, Civitas seeks an order pulling all uncommitted interests in a portion of the Bone Spring, which I'll elaborate on shortly. The requested spacing unit is 480 acres, comprised of the southeast quarter of Section 3 and the east half of Section 10, Township 25 South, Range 35 East, and seeks to dedicate this unit to its first T wells. There's not an ownership depth severance in the Bone Spring, but rather, like I alluded to earlier, Civitas and COG entered into an agreement where Civitas will develop the top of the Bone Spring formation to the base of the second Bone Spring interval, and COG will develop the lower Bone Spring and the Wolf Camp. And those cases pertain to the COG cases pertain to items 9 through 11 on today's docket. And the exhibits included are Exhibit A, the testimony of land manager Sean Johnson and related exhibits. Exhibit B is the testimony of geologist Shane Finnegan and related exhibits. Both witnesses have testified before the division as experts in their respective disciplines. And Exhibit C contains my self-affirmed statement of notice confirming notice was sent by certified mail on April 17th, 2025 and published on April 18th, 2025. And with that, I request all exhibits be admitted into the record and this case be taken under advisement.
Without objection. Mr. Fordyce, you are the technical examiner for this case?
Yes.
All right. Are you also the technical examiner for the next 3 cases as well?
Yes, Mr. Hearing Examiner, I am.
Okay, very good. Do you have any questions for the witnesses in this case?
Yeah, I have questions for the landman.
Perfect. Let's get the landman on the camera and sworn in.
And I apologize. Mr. Johnson is the witness in this case. However, he has a personal matter that came up and he's unavailable today. However, I do have Chad Matney standing in and he's familiar with the land matters.
Let's get Mr. Matting.
Yes, I can bring somebody in.
I'm sorry, I didn't hear you. Okay, thank you, Ms. Chance. Mr. Matney, would you raise your right hand, please? Do you swear or affirm under penalty of perjury that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
State and spell your name for the record.
Chad, C-H-A-D, last name Matney, M-A-T-N-E-Y.
Okay, and you've been accepted by this division as an expert in what field?
In land.
Thank you. Please proceed, Mr. Fordyce.
Yes, Mr. Matney, if I could direct your attention to page 6 of the exhibit packet and to paragraph number 10, and just wanted to reiterate your testimony there is that ownership is uniform within the Bone Spring Formation, and there's no depth severance, correct?
That is correct, yes.
If we could now go to page 23 of the exhibit packet. And just again, for clarification, this is showing that in tract 1, which is a federal tract, Civitas has 77% of the interest there, and COG operating has 23%, correct?
Correct.
And in tract 2, the fee tract, there was numerous parties that were identified and some of those that are being pooled, correct?
Correct.
Okay, thank you. Maybe that was more for clarification than a direct question. I appreciate it. Thank you. No further questions.
Mr. Fordyce, do you have any questions for any other witnesses?
No, I do not.
Can we take this case under advisement?
Yes, we can.
All right, we're off the record in case number 8. Now I'm calling case numbers 25349, 50, and 51. Entries of appearance, please.
Good morning, Mr. Hearing Examiner. Paula Vance with the Santa Fe office of Holland and Hart on behalf of the applicant, COG Operating.
Thank you.
Mr. Examiner, Jim Bruce on behalf of MRC Hat Mesa LLC and MRC Royalties LLC. They have no objection to the matters proceeding by affidavit, and I will not be asking any questions.
Thank you. Ms. Vance.
Thank you, Mr. Hearing Examiner. So in all 3 of these cases, the acreage is in Township 25 South, Range 35 East, and that's Lee County. In case number 25349, COG is seeking to pool all the uncommitted interests in a portion of the Bone Spring from the top of the 3rd Bone Spring to the base, and that would be in a wildcat pool. It's a lower Bone Spring, and the pool code is 9818. 70185, and that's underlying a standard 480 acre, more or less horizontal well spacing unit comprised of the southeast quarter of section 3 and the east half of section 10, and dedicating that unit to the Montera Federal Com 603H. Then in case number 25350, COG is seeking to pool the uncommitted interest in the Wolf Camp formation, and that pool is the Doggy Draw Wolf Camp, and pool code is 17980, and that is underlying a standard 240 acre, more or less, horizontal well spacing unit comprised of the west half of the southeast quarter of section 3 and the west half of the east half of section 10, and dedicating that to the Montera Federal Com 701H. And then lastly is case number 25351, and COG seeks to pool all the uncommitted interests in the Wolf Camp formation. Again, same pool, the Doggy Draw Wolf Camp, pool code 17980, and that is underlying a standard 240 acre, more or less, horizontal well spacing unit comprised of the west half of the southeast quarter. Oh, I'm sorry. I believe I'm repeating myself on that one. Give me one moment. It's the east half of the southeast quarter of section 3 and the east half of the east half of section 10. My apologies. And dedicating that unit to the Montera Federal Com 702H. In each of the hearing packets, we have included a copy of the application, the CPAC, and the test statement from landman Carolyn Frederick and geologist Tyler Patrick, along with the sub-exhibits. Both of our experts have previously testified before the division, and their credentials have been accepted as a matter of record. And then we have my self-affirmed statement of notice, it's either myself or my colleague, Mr. Rankin, and those letters are dated April 18th and May 7th, 2025, and then an affidavit of notice of publication. There is one for April 24th and May 9th, 2025. And unless there are any questions, I would ask that the exhibits and sub-exhibits be admitted into the record and these cases be taken under advisement.
Without exception, Mr. Fordyce?
He's on mute. Or we can't hear you.
Can you hear me now? I have questions for the landman, Mr. Examiner.
Is that the person whose screen is on here?
Yes,
Okay,
I'm
perfect.
here.
Perfect. Thanks for anticipating. Would you raise your right hand, please? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth under penalty of perjury?
I do.
Would you state and spell your name for the record?
Yes. Caroline, Caroline, Frederick, Frederick.
Okay. And have you been accepted as an expert before this division?
Yes, sir.
In what field?
Petroleum land.
Thank you. Mr. Fordyce?
Yes, if I could direct your attention to page 19 of the revised exhibit packet.
Yes, sir. I'm following.
So it says here in tract 1, the federal lease.
Yes, sir.
That COG operating has 100% of the interest?
Yes. So the difference between the first and second Bone Spring, so Civitas and COG reached a co-development agreement via term assignment. So in the first and second Bone Spring, the ownership for Civitas will be showing differently than it is for the third Bone Spring and Wolfcamp A, because we did a term assignment of COG's interest in the first and second Bone Spring.
So for this case, the Bone Spring case, it will then be identical to what is being shown for the Wolfcamp cases?
Yes, sir.
Okay, that makes sense. No further questions for this witness.
Okay. Can we take these, well, do you have questions for any other witness?
I do have some other corrections to point out for Ms. Vance. In
Correction.
case 25349, on page 5, which is the application checklist, for pool name and pool code, the pool name is listed, but is missing the pool code. And also in this revised exhibit packet, the revision was to correct exhibits D1 through D3, and they still have errors. They are the same exhibits. Those are on pages 32 to 34. They're still showing that the spacing unit goes too far north, actually up into the northeast quarter of section 3. Also in case 25350, a revised packet was submitted to correct an issue with a C102 and the same exhibits D1 through D3. And D1 through D3 did get corrected, but the C102 did not. And in that case, if you want to look, the C102 is on page 15 for case 25350.
And what did not get corrected? I just want to make sure that I understand for the C102.
The spacing unit is depicted incorrectly, and that was supposed to be corrected with revised exhibits, and it is still the same.
I will do a review with our experts and make sure that we get corrected C102 and geology exhibits and refile revised exhibits accordingly.
This goes beyond the simple typo. So we're going to continue these cases to the next hearing by affidavit docket. So you have some time to do this. Anything further?
No.
Thank you. All right, we're off the record in these cases. We're moving on now to number 12, Chevron USA 25352. Entry of appearance, please.
I have one question. Which hearing date am I continuing to for?
The August 7, I believe.
Okay.
For the July 10th?
I'm sorry. Thank you. You said July 10?
Correct.
Thank you. July 10.
Thank you.
Okay. Entry of appearance, please.
Good morning, Mr. Hearing Examiner Paula Vance with the Santa Fe office of Holland and Hart on behalf of the applicant, Chevron USA.
Thank you. Are there any other parties that you know of?
No.
Okay, please proceed.
You'll give me just one moment to pull up my materials here. So this is pretty straightforward, and I'm glad to see Mr. McClure. He is familiar with this application, and I believe is familiar with Chevron's separate administrative application for commingling. We're simply here today to request an amendment to an existing order. That order is TAC 20250. Under that order, the Javelina unit is approved, but it also approves surface commingling for oil and gas production from both the Bone Spring and the Wolf Camp. So what we're simply asking here today is to dismiss the commingling authority under that order, and that it will simultaneously once it's reviewed administratively, we'll get approval for that. And so there's a twofold action here, and I believe Mr. McClure is familiar with it. Anyway, we have provided a self-affirmed statement of notice, which was timely, in a sample letter. that went out of the notice, which was timely mailed on April 18th, 2025, and then a notice of publication that was timely published on April 22nd, 2025. I did not include any statement, but we do have our landman available should the technical examiner or the hearing examiner have any questions. Unless there are any questions, I would ask that you take the exhibits under advisement at this time.
Thank you. Without objection, Mr. McClure,
No questions for this case, Mr. Hearing Examiner.
this case will be taken under advisement. Thank you. Okay, we're now moving on to number 13 on the docket. This is 25365 Mewburn Oil.
Good morning, Mr. Hearing Examiner. Paula Vance with the Santa Fe office of Holland and Hart on behalf of the applicant, Mewburn Oil Company.
Are there any other parties?
Not that I am aware of, no.
Thank you. Please proceed.
Thank you. So in case number 25365, Mewburn seeks to pool all the uncommitted interests in a 640-acre, more or less well-spacing unit in the Bone Spring Formation, and the pool that Mewburn was provided is the Vacuum Bone Spring South, pool code 61900, and that's underlying the east half of sections 15 and 22, Township 18 South, Range 35 East, and that's in Lee County, New Mexico. And Mewburn seeks to initially dedicate that spacing unit to the Seafood Tower 2215 Statecom 527H. In our hearing packet, we have included a copy of the application, the CPAC, a statement from landman Peyton Warren, and a statement from geologist Charles Crosby, both of whom have previously testified before the division, and their credentials have been accepted as a matter of record. We have included all the standard sub-exhibits for land and geology, and then following that is a self-affirmed statement of notice with a sample letter that went out and was timely marked April 18th, 2025, and then an affidavit of notice of publication, which was timely published on April 24th, 2025. And unless there are any questions, I would ask that the exhibits and sub-exhibits be admitted into the record and the case be taken under advisement.
Without objection, Mr. McClure.
Thank you, Mr. Hearing Examiner. I have a few questions for Ms. Vance in regards to notice.
Please proceed.
Ms. Vance, is it your understanding that there was some written notice that was returned to sender for this application?
If the tracking report states that, then that is what we received back from our vendor.
Yeah, I was going to say, I know there's at least one that it appears that it was returned to sender. As such, are you in agreement that the public notice is what's being used to cure that?
Correct.
Okay, on your last page of the application, you have the newspaper clipping there. It appears that the case number that is listed there is incorrect. Am I missing anything, or is there any other clipping for us to look at here?
No, that was a Scrivener error. But if you notice, there is information regarding the actual substantive nature of this application, including the land description, and then contact information for the division, how to make an appearance at the hearing, et cetera.
If the applicant was to want to review the case file online, as would be the normal way to do so, would they be directed to the correct case using this case number on this newspaper clipping?
No, but there is contact information for the division if that was incorrect. And so there is an avenue for clarification.
Mr. Hearing Examiner, I don't have any more questions for Ms. Vance, but I do think this may justify a dismissal and submission.
Okay. Ms. Vance?
I don't I disagree with Mr. McClure. Scrivener errors happen. Ms. Chance's contact information with the division is there. And I don't believe that it actually would warrant dismissing the case. If anything, we could rerun the notice if that were to be required. However, that being said, I do believe that these have a time sensitivity to them. So again, we would definitely not want to dismiss this. That seems.
So your proposed cure is what?
Well, one, I don't think that there is anything to cure here. I think it's cured by the fact that if there is a Scrivener error, there are avenues to be able to contact the division and get clarification. But second, if we do need to do anything, then we could do run a second notice of publication with a corrected case number.
And the notice of publication was to satisfy the rule. And it's necessary in this case because you were unable to contact some interest owner. Is that right?
Based on what Mr. McClure has pointed out, it looks like maybe one of the notices was returned. On that note, I would want to check with our landman to see, well, first of all, which party, I don't want to ask Mr. McClure directly unless I can, but which party that was, because it's possible that we can get notice to that party another way very quickly.
Do you have your landman on here?
Yes, Ms. Warren is available.
Okay, do we have Ms. Warren?
Yes.
When I see your picture, we'll get you sworn in. There you are. Okay. Ms. Warren, would you raise your right hand, please? Is the testimony you're about to give under penalty of perjury the truth, the whole truth, and nothing but the truth?
Yes.
Very good. Would you state and spell your name, please?
Peyton Warren. That's Peyton. Warren, Warren.
Thank you. And you have been accepted as an expert before this division?
Yes, sir.
In what field?
Petroleum land.
Okay. Now, Ms. Vance, go ahead.
Well, first of all, can I would just ask, can we get clarification on which particular party Mr. McClure was concerned about?
Mr. McClure, are you comfortable giving clarification?
Yeah, I have no problem, Mr. Hearing Examiner. Yeah, I'm just looking at your notice spreadsheet, and I noticed that I believe there's some that it doesn't have reference to it actually being delivered. So there might be a few additional that this question's about that may trigger the need for public notice. But at the very least, a Glenwood Resources Incorporated, you have the current status listed as your item has been delivered to the original sender at 11:18 a.m. on May 5th.
Does that
You
help,
see where
Ms.
I'm-
Vance?
Yes. So, and I would want to go up to Ms. Warren's.
Why don't we do this so that you ask all the questions you need to? Let's take a 5-minute break so you can gather yourself, and Ms. Warren can look at this information as well, and then we'll get some real answers.
Yeah, can I just state one thing
ahead.
on the record real quick? So I'm looking at the actual parties that we're pooling, and it looks like there's only 3 parties. So I think if we can just confirm, we might have provided more notice than we needed to. So I just will confirm that the 3 parties that we are actually pooling received notice, and that might cure everything.
I'm not sure that the rule says that you only need to give notice to parties that you intend to pool, though. That's where we might differ.
I believe that that is the requirement, and I would have to look into the rules, but that's been my understanding, is that we only need to provide notice to the parties to be pooled.
It says, I'm reading from the rule, and you have time. I'll give you 5 minutes to look at this if you like as well. But my understanding of the rule, and I'm reading from the same rule I read earlier today, 1915-412, A1A, and this is a compulsory pooling case, is it not?
Yes.
Okay, very good. It says here, the applicant shall give notice to each owner of an interest in the mineral estate of any portion of the lands the applicant proposes to be pooled or unitized, whose interest is evidenced by a written conveyance document, either of record or known to the applicant at the time the applicant filed the application. Now, that doesn't seem to fit with what you're saying.
I may differ in my opinion of that
Mhm.
interpretation.
Mhm.
But again, I would want to dive in a little bit deeper. But again, it's always been, and I think that there has been a conversation about this with some of the other council that notice is just to the parties to be pooled. And that's what it has always been.
Well, why don't you want to take you want a 10-minute break so you can do
Yeah,
both?
that sounds great.
Let's do a 10-minute break. Thank you. We're off the record. Shy. I'm not shy.
a couple of points walking through the rules. So one, I know the hearing examiner pointed to the rule 1915-412 regarding notice. And just reading through that, I think, so the applicant shall give notice to each owner of an interest in the mineral estate of any portion of the lands the applicant proposes to be pooled or unitized, whose interest is evidenced by a written conveyance document, either of record or known to the applicant at the time the applicant filed the application, and whose interest has not been voluntarily committed to the area proposed to be pooled. So there's two pieces there. It is that they have a written conveyance and they have not volunteered their interest. So it is just pooled parties. Second, if you go down to B of the same rule and you look at the requirements for a notice of publication, that is, you rely on the notice of publication when you do not have a locatable address. For the parties that Mr. McClure was pointing to, there was an address. It is the last known address in the public record. Yes, we use it to try to cover where we don't have a working address, and perhaps if something is not delivered, but the intent for the notice of publication is when you don't actually have an address. That being said, the three parties that Mewbourne is seeking to pool, which if we go to the, and I'm going to share my screen. So if we go to Mewbourne's pooling exhibit, page 16, which shows the three parties that Mewbourne is seeking to pool, Contega, Rich Sharpenter, and the Drusilla. They are highlighted there. And then we go to the mailing report. You can see that for each of these parties, they were delivered or picked up successfully. So I believe for the three parties that we were required to provide notice to that are being pooled, we have satisfied the notice. And I would ask that the division take this case under advisement.
Okay, so let's go back to your argument about A1A and where it says, and whose interest has not been voluntarily committed to the area proposed to be pooled or unitized. I can see your argument there, but it seems as though it's a different argument to say we're only pooling certain people, so those people we need to provide notice to, versus whose interest has not been voluntarily committed. Because I could see that the two groups of people could diverge possibly in certain circumstances. I think what you're saying here is, in this case, they're not.
Correct. And I agree with the examiner, and there are definitely instances where that may happen, but that is a risk that a applicant would be taking on if they did not provide notice and weren't pooling that person.
So I can understand your argument here in this case, especially given that the clause following and. So that satisfies me to that extent. Now you say in B, you were saying that in B, as long as you have an address, you don't need to, and you send it to that address, you don't need to publish notice.
I'm just reading what it says here. When an applicant has been unable to locate persons entitled to notice after exercising due reasonable diligence.
Where are you? I'm not in the same B that you are. Where are you?
I am, if you are.
Are you A1B?
No, I am 1915-412B, so you'll need to.
Big B?
Big B.
No wonder.
Correct.
Hold on. Type in content of notice?
Yes.
Okay, go ahead.
When an applicant has been unable to locate persons entitled to notice after exercising reasonable diligence, which typically in the land statement, you will see that there's always a statement related to due diligence to search for parties. The applicant shall provide notice by publication and submit proof of publication at the hearing.
So what was your argument regarding addresses that you made earlier?
So your landman will do a diligent search of the public record. If there is a address or potentially they come up with multiple addresses, they will try those. But that would be considered a locatable party. Even if it gets returned, you have located a address for that party because it's the last known address in the public record. But there are plenty of instances where perhaps you have a party where there is no address, and that's where you're really relying on your notice of publication.
Let me go back for a moment. And I'm glad we're having this discussion. Because in the small b under A, compulsory pooling, in the section that deals with compulsory pooling and statutory unitization, we have talked about A so far. But there's small b there. And small b says, when the applicant has given notice as required by A, of a compulsory pooling application, and those owners the applicant has located do not oppose the application, the applicant may file the following under the following alternative procedure. Now, B, I mean, if I go by your interpretation, Ms. Vance, then as long as you have an address for someone and send out a certified, et cetera, if you follow this here, you don't actually have to make contact with that person.
That's correct. Because it's based on a good faith effort and a reasonably diligent search to find the party.
When an applicant has been unable to locate persons entitled to notice after exercising reasonable diligence, the applicant shall provide notice by publication. So then in your scenario, or you're asserting that, let's say you have 3 people that you've been able to locate by last known address, and you send them certified mail. You don't need to provide notice by publication if you've done that, is what you're saying.
Correct. And there are plenty of instances where I have not included a notice of publication because you can see from the tracking report that we completed the notice. And in this case, if I wasn't so busy, I may have done that.
Well, I'll think about that, but I don't think that's dispositive of today's because you did publish notice. It's the wrong case number in your notice, but you're saying, okay, so let's talk about, so do you have questions now for your landman?
I do not, but
Do not.
again, I just want to be clear, I would be happy to provide a revised hearing packet that drops the notice of publication because we don't need to rely on it. And I think that may get rid of some of the confusion since there was a Scrivener error on the notice of publication. We have 3 parties we are pooling. The notice got to those parties according to our tracking report. We have met the intent of the rule.
Okay, so let's not use that phrase. I thought we just agreed that there are times when there's a mineral interest owner who has not been voluntarily committed to the area that may not be on your list of pooled parties.
Correct.
Okay, so let's not use that term that just because you're not pooling them, they don't deserve notice.
Can you explain that?
I thought we already agreed earlier that there are times when just because you're not pooling someone doesn't necessarily mean that they have a voluntary agreement.
Correct.
So then so let's not say it that way anymore, because it looks like automatically if you're not pooling them, they don't deserve notice, and that's not what the rule says, is all I'm saying.
Fair.
Okay, all right. So can we go to your list of parties or whatever exhibit that is?
Sure.
And we have your witness still available, don't we?
Yes, I believe Ms. Warren is still available.
Okay, perfect. Okay, there we go. Okay. Mr. McClure, do you have any questions based on notice on this exhibit?
I mean, I do have some questions as to what was the reason the different people were noticed, I guess. Would you like me to address that with the landman, Mr. Hearing Examiner?
I think that's the appropriate witness.
Okay.
I don't see her though. There we go. Okay, Ms. Warren, I remind you, you're under oath.
Yes, sir.
Are we not going to have that exhibit? That's okay. There we go. Okay, thank you.
Ms. Warren, can I draw your attention to the list of persons in the notice spreadsheet? That is on page 29 of 33 is where it starts on the exhibit packet.
Yes, sir.
Can you
On
change
here,
it, Ms. Vance? 29, please. Hold on, Mr. McClure. We're changing the on the screen to 29. There we go.
Very good. Ms. Warren, I didn't count these, but just throwing a number out there, maybe like 30 persons is included in this table. Does that seem about right to you?
Yes, sir.
Do you know the reason that all these people were provided notice?
Yes, around the time that we provided notice to the parties, there was an assignment and bill of sale filed in the Lee County, New Mexico records, and those assignments included the majority of those parties, and they assigned their interest to Three Forks Resources LLC, who then immediately turned around another assignment and bill of sale to Lario Permian 2 LLC, who then voluntarily signed our joint operating agreement.
Okay, so then the majority of these persons, their interest is now owned by L'Oreal Permian number 2 LLC. Is that correct?
Yes, sir.
Does that include the interests of Glenwood Resources Incorporated?
Yes, sir.
As far as the returning green cards, is that something that Mewborn gets, or is that something that Harlan and Hart would have?
I believe that's Holland and Hart.
Okay, I don't have any more questions for this witness, Mr. Hearing Examiner. But I would just ask Ms. Vance if she happens to have the green cards for the return or for the.
I could pull from the tracking information, the tracking numbers that are included there, and just file the full, the full transit of the mailing that went out, if the hearing examiner or the technical examiner would like that.
Well, Ms. Vance, go ahead, Mr. Hearing Examiner.
No, I didn't know you were going to say something. Go ahead.
Ms. Vance, I was going to say I have access to that myself, and I'm looking at it. And I'm not sure if it's an error in the postal service or if it was to an incorrect address or not. Was how these sent? Were they sent with green cards getting sent back, or is that not the case?
I'm not sure I understand your question. Is it related to the parties that are being pooled?
I'm asking about Loria Permium. Number 2 LLC is the one I'm curious if they've received notice.
I would have to pull up the tracking report for that, but what's summarized there in that far right corner is the most up-to-date information regarding the mailing as of the date stated in my statement.
Okay, I guess to re-ask my question, how you sent these letters, this notice, do you receive the green card once it's been signed, or is it only tracked online?
As far as I understand, it's only tracked online. We work with a vendor, and my legal assistant manages our notice that goes out. So I oversee it, but I would have to ask her. As far as I understand, we just track it online.
Okay, that answers my question, Ms. Vance.
So, Mr. McClure, how do you want to proceed?
I would like them to reconduct notice is how I'd like to proceed.
Okay.
Reconduct the public notice.
Okay. Do you mean the publication, or do you mean the direct mailings, or both?
I mean, I guess at their discretion, they could try to do the direct mailing again, but I think if they just renotice it publicly, I think that should be sufficient.
Okay, Ms. Vance?
I don't believe we need to. We have provided notice. It is in the tracking report to the parties that Mewburn is seeking that have not volunteered, that are in the pooling exhibit. Those parties have received notice. There is no reason for us to do a notice of publication.
Why did you publish notice?
We always do that as a catch-all, but we don't need to necessarily rely on it. Obviously, we included it in our hearing packet, but again, I am happy to drop that and just show in our the mailing report just for the 3 parties that we are pooling. That way, there is no confusion. We provided that notice. It's clear from the tracking report that it was delivered and received by those parties, and there is no reason for us to rely on the notice of publication.
Well, if the technical examiner wants published notice, I'm not going to go against that.
I just need to understand the basis. If the rule requires that we provide notice and we are showing with our evidence that notice was provided, those parties received it, then there is no basis for us to do a notice of publication.
So is there a list of parties in your spreadsheet here of all the people you sent notice to?
The tracking report, correct.
Can you pull that up? Is this the whole? How many pages is this?
1, 4. And again, you can see the parties that are highlighted to be pooled. Contago, this was delivered. For Drusilla, was picked up. And for Rich Sharpenter Living Trust, it was delivered.
So based on the way the rule is written, first of all, where does this, and I need you to educate me on this because I don't know where this list comes from. How do you obtain this list here?
This is provided by our landman. So when we are preparing, we get a notice list from our landman. Ms. Warren provided this to me.
I see.
And it's not static. So Ms. Warren is, from the time she is sending this notice list to us, she is continuing those negotiations with the parties and trying to get that voluntary agreement. And then by the time we get to hearing and getting ready to file our hearing packet, we may have notice parties that we now have agreement with.
I see. So Ms. Warren, you heard that, right?
Yes, sir.
All right, good. So you provided, and I can't see this entire list. Can you go up to the top?
Sure.
Okay. Okay, so Ms. Warren, this is the top of the list. When did you provide this list to Ms. Vance?
It was several months ago, and this was the initial list we gave her, and so that's who we asked her to notice while we continued negotiations.
Okay. Okay, so there's no date on this exhibit. Is that right?
Yes, and I would say, so I also would add that there has been additional time because this was originally filed April 14th. So there has been additional time, rather than, just a month, there's been a couple of months. We continued this case, or rather, I think it was continued by the division because the docket was full. Mm-hmm. So there has been additional time that Ms. Warren has had to get those voluntary agreements with parties.
Okay, I'm not sure. Okay, thank you. I appreciate that. So Ms. Warren, how do you compile this 4-page document?
Yes, these are the list of mineral interest and leasehold interest owners that we compiled when we were preparing to propose the well to the parties in the unit. And that was our initial list who we proposed to, and afterwards, the majority of which assigned their interest to Three Forks, who assigned their interest to Lario.
Okay. So you're saying that all the people on this list are mineral interest owners or leasehold owners in this tract of land?
Yes, sir.
Okay. Some of them have voluntarily committed their interest and some of them have not.
Correct.
Okay, very good. But does it show on here who has voluntarily committed their interest and who has not?
The table if you scroll up on the exhibit packet, it shows 2 parties who are committed and who have voluntarily signed our joint operating agreement.
Ms. Warren, excuse me for interrupting you. Please use exhibit numbers when we talk for the record, because otherwise a court reporter is not going to know what we're talking about.
Sir.
I believe that Ms. Warren was referring to Exhibit C2, which is the pooling exhibit. Is that correct?
Yes.
Okay, I am there. I believe this is what Ms. Warren was referring to.
Can you see this exhibit, Ms. Warren?
Yes, sir.
Is this the whole exhibit? Are we missing part of
it? It is a couple of pages here. So whichever she would like me to go to, I'm happy to scroll.
Okay, Ms. Warren, where are you talking about here?
This page works. Under tract ownership, we have Mewburn, Marshall and Winston, and Lario 2, who have voluntarily signed our joint operating agreement, and the remaining 3 parties are who we intend to pool.
Okay, I understand. So that's why in that other spreadsheet that we looked at, what was that exhibit number with the spreadsheet?
That would be Exhibit E.
Which one?
Exhibit E, the one with the mailing report?
Yes.
Yes.
E like Echo?
Yeah.
Is that the 4-page
Correct.
exhibit? That list is, you received that from Ms. Warren?
Yes, well, that's the mailing report based on the notice list she provided me. Yes.
Okay. So Ms. Warren, then what you're saying is that long 4-page list, that spreadsheet of all those interest owners, you're saying the great majority of them, the very great majority of those people assign their interest to these 3 individuals, Mewborn, Marshall, and Lario? Is that what you were saying?
Yes, sir. Actually, most of which went to Lario.
Right, that is what you said before.
Yes, sir.
Okay, and Lario has a JOA with you?
Yes, sir. They have signed our joint operating agreement.
So out of all the people on that long 4-page exhibit E, as in Echo,
Correct.
of all those people, there are only 3 people or 3 entities that have not voluntarily joined in this endeavor. Is that correct?
Correct.
Okay, and those are the 3 people highlighted here on this exhibit C2.
Yes, sir.
All right. Now, Ms. Vance, your testimony as to these 3 individuals or entities, you've mailed notice to all 3 of these people.
Correct.
Okay. And you succeeded in having your mailing received.
That is what the mailing report reflects. Correct.
Okay. And Miss Warren, do you say the same thing?
Yes, sir.
Okay. Mr. McClure, have I missed something here that the 3 people who have not voluntarily joined their mineral interest ownership in this area, the subject lands, we'll call it, am I missing something here that they did not receive, that they did actually receive actual notice?
I was going to say, based upon the verbal testimony here, it seems that what they're verbally testifying to is that L'Oreal Permium number 2 LLC assigned their JOA. Looking at the most expedient path to them getting an order, though, I mean, we still need to have, further discussion beyond the scope of this hearing as to the interpretation of that rule, though. So we may be looking at a longer period if we don't go down the route of just taking care of the notice.
And I think the best thing to do at this point would have taken another 5-minute break. So we're going to be off the record for 5 minutes. Thank you. All right, it is 11:18 a.m. We are back on the record, and after a lengthy discussion, we will take this case under advisement. Thank you.
Thank you.
All right, moving on to Permian resource cases. These are three cases joined together, 25372, 73, and 74. Introduce your appearance, please.
Mr. Examiner, Dana Hardy with Hardy McLean on behalf of Permian Resources, and there are no other parties.
Perfect. Please proceed.
Thank you. In these cases, Colgate, it's actually Colgate, is the applicant, Permian Resources is the operator. Colgate seeks to extend the drilling deadline under orders numbers R23218, 19, and 20. This is the first extension for these wells. We've provided with our exhibits the statement of landman Ryan Curry. Mr. Curry explains that Colgate requests the extension so it can co-develop the Alpine wells with the offset Terlingua wells, which are located in an adjacent section, in section 6. And those have been previously pooled and recognized by the division. Co-developing the wells will prevent parent-child effects and reduce cost, and therefore prevent waste. I forgot to state that Mr. Curry has previously been recognized as an expert, but he testified earlier this morning. Exhibit B is our notice information. Notice was timely sent by certified mail on May 6th, 2025, and notice was timely published on May 15th, 2025. So with that, I request that the exhibits be admitted and that the cases be taken under advisement.
Without objection, Mr. McClure?
Yes, Mr. Examiner, I have a question for Ms. Hardy in regards to the notice.
Thank you. Go right ahead.
Sure.
Ms. Hardy, when was written notice provided?
On a couple of the cases, actually, I think on all of these, it was on May 6th.
Okay. I was going to say, I don't have it right in front of me, but I believe it's page 16 of 35, your exhibit B1, the notice letter. It has a date at the top of the page. Is that date a typo?
Let me get there. Yes, it is. I believe that likely what happened is that when we printed the exhibit, Microsoft Word automatically updated the date. Because if you look at our certified mailing report, which starts on, it's exhibit B2, it starts on page 18, it shows that the mailing date was May 6th.
Okay, thank you. So the May 6th is the correct date then?
It is, yes. Thank you.
Okay, thank you, Ms. Hardy. Thank you, Mr. Hearing Examiner. I have no further questions for any of these three cases, I think, correct? Yep.
Yes. Okay, can we take them under advisement?
Yes, sir, we can.
Perfect, thank you.
Thank you.
Moving on to MAC Energy. This is case 25375. Introduce your appearance, please.
Good morning, Mr. Hearing Examiner Paula Vance with the Santa Fe office of Holland and Hart on behalf of the applicant, MAC Oil, and Chase Oil Corporation. They are sister entities.
And are there any other parties?
No.
Please proceed.
Yes, so this is just a request for extension. In the hearing packet, we included a copy of the application, the original order. We also included a self-affirmed statement from landman Derek Smith. He has previously testified before the division. His credentials have been accepted as a matter of record. We did provide an updated pooling exhibit because MAC reached voluntary agreement, I believe, with one of the parties. And then I've also included a self-affirmed statement of notice with a sample letter that was timely mailed out on May 16th, 2025. And then the affidavit of notice of publication, which was published timely May 22nd, 2025. Unless there are any questions, I guess I'll point to the good cause real quick.
Thank you.
Sorry about that. MAC is working with the state land office on an approval related to, I believe, saltwater injection. So it's just working on some infrastructure related to the development. Again, unless there's any questions, I would ask that the exhibits and sub-exhibit be admitted into the record and the case be taken under advisement.
Without objection, Mr. McClure, any questions?
Yes, I do, Mr. Hearing Examiner, for Ms. Vance in regards to notice.
Okay.
Miss,
Please.
thank you, Mr. Examiner. Ms. Vance, does it appear that public notice was required in this case?
No, it does not, because all of the notice was delivered, but we did include it. Again, it's just sort of a standard practice that I have put in there. And I've been busy. I have a colleague that is out on a very well-deserved sabbatical. And so had I looked at this a little bit closer, I probably would have dropped that notice of publication.
Yeah, Ms. Vance, it's not necessary to drop the notice of publication in it. I just needed you to verbally confirm for me that you do believe that it's not required. In this particular instance, the division is in agreement with you that it wasn't required. In this case, the public's notice, the reason I asked, because it was not sufficient because of the date.
Oh,
But
yes, I believe it may have been one day late. Yeah.
That's correct.
Yeah.
Thank you, Ms. Vance. So, Mr. Hearing Examiner, I have no further questions. I believe we can take the case under advisement.
Thank you. We'll take the case under advisement. We're off the record. Let's go on to number 18 on our docket. This is XTO Permian operating case 25377. Entries of appearance, please.
Good morning, Mr. Examiner. Miguel Suazo with Beatty and Wozniak appearing today on behalf of Permian Operating LLC. Sorry, XTO Permian Operating.
And are there any other parties that you know of?
No, Mr. Examiner.
Okay, please proceed.
Sure. In this case, XTO Permian Operating is requesting an application to approve a non-standard horizontal spacing unit, approving 799.77 acres more or less, comprised of the east half of the northeast quarter and southeast quarter of section 1, the east half of section 12, and the northeast quarter of section 13, township 24 south, range 29 east, Eddy County. This would be comprised of the following wells: the Poker Lake Unit 13-24 PC 108H, 118H, 127H, 127H, and 168H. And these will be producing from the Purple Sage Wolf Camp Formation. The exhibit packet that was filed on May 5th of this year. Exhibit A is the application and proposed notice of hearing. Exhibit B is the affidavit of commercial land manager Corey Matthews. Ms. Matthews has previously testified before the division, and her qualifications have been accepted and made a matter of record. Exhibits B1 through 3 are the standard suite of land exhibits, including C102s, map of the standard spacing unit, and map of the non-standard spacing unit. Exhibit C is the affidavit of senior geoscientist Jennifer McCarge. Ms. McCarge has also testified before the division, and her qualifications have been accepted and made a matter of record. Exhibit C1 through C5 are the standard suite of geology exhibits, including the location map, base map, subsea structure map, cross-section of the formation, gun barrel diagram, and isopac map. Exhibit D is the notice affidavit showing that notice letters were mailed on May 14th and the addresses of record to the interested parties and mailing receipts. Exhibit E is the publication in the Carlsbad Current Argus, which ran on May 17th, 2025. And with that, unless there's any questions, I'd like to ask that these exhibits be admitted into the record and these matters be taken under advisement.
Without objection, Mr. McClure?
I'd have a question for the landman.
Okay, Mrs. Suazo?
Yes, it's Corey Matthews. I believe she's available online.
Thank you. Good morning, Ms. Matthews. Would you raise your right hand, please?
Yes.
Do you swear or affirm under penalty of perjury that the testimony you're about to give is the truth, the whole truth, nothing but truth?
I do.
Would you state and spell your name?
Yes, Corey Matthews, Corie, Matthews, Mathews.
Okay, and you've been admitted as an expert or recognized as an expert in what field before this division?
Petroleum land.
Okay, perfect. Mr. McClure?
Ms. Matthews, did XTO contact Devin in regards to this application?
Yes, we did.
Okay, and do you know what the result was of that conversation?
Yes, we were able to work out an agreement in which both parties are happy, and that's the reason why they did not protest today.
Okay, thank you, Ms. Matthews. Thank you,
Of
Mr.
course.
Hearing Exam. Yep. Thank you, Mr. Hearing Examiner. No further questions.
All right, we'll take this case under advisement. Thank you, Mr. Suazo. Moving on to number 19 on the docket. It looks like it's, well, I guess it's not joined with the other Mewbourne oil cases. We'll just call it by itself. 25383.
Mr. Examiner, Dana Hardy with Hardy McLean on behalf of Mewbourne Oil Company, and there are no other parties.
Please.
Thank you. Mewbourne seeks an order pooling all uncommitted interest in the Bone Spring Formation underlying a 160-acre standard horizontal spacing unit comprised of the east half of Section 27, Township 23 South, Range 28 East in Eddy County, and will dedicate the unit to the Speedwagon 27 Fee 528 well. Our exhibit. Okay. Our exhibit packet includes the self-affirmed statements of landman Mitch Robb and geologist Tyler Hill, both of whom have previously testified and been recognized as experts by the division. Mr. Robb provides the standard land exhibits. The plat of tracts, ownership interest, and pooled parties information is provided in Exhibit A3, and Mewbourne does own over 98% of the interest in this unit, so they're only pooling a couple of very small interests. Mr. Hill provides the standard geology exhibits, a location map, structure map, and cross-section. Exhibit C is our notice information and shows that notice was timely sent by certified mail on May 7th, 2025, and was timely published on May 15th, 2025. With that, I request that the exhibits be accepted into the record and that the case be taken under advisement. Thank you.
Thank you, Ms. Hardy. Without exception. Mr. McClure?
Mr. Examiner, I have a question for the landman in these cases.
Okay. And who is that, Ms.
That is Mr. Mitch Robb. He should be on the platform. I see him there.
Mr. Robb, would you please raise your right hand? Do you swear or affirm under penalty of perjury that the testimony you're about to give is the truth, the whole truth, and nothing but the truth? Not possible to hear you, sir.
You're mute.
He's on
Because you're on mute.
Yes, I do.
Okay, you can put your hand down. Would you state and spell your name for the record?
Mitch Robb, MITCHROBB.
And this division has recognized you as an expert in what field?
Petroleum land.
Okay, Mr. McClure?
Thank you, Mr. Hearing Examiner. Mr. Robb, I'm looking at your exhibit A3 found on page 13 of 29.
Okay.
Listed here, there's a row, I guess the second table, the table is kind of in the middle of the screen. It says Mewbourne Oil Company et al. Do you see where I'm referring to?
Yes, I do.
Which persons is that row referencing?
That's Mewbourne combined with all parties who have signed our JOA. There's a lot.
And is that list of et al. Included in this application packet anywhere?
No, it is not.
And if I were to ask you to provide that, do you understand what I'm asking for?
Yes.
Okay, no more questions, Mr. Hearing Examiner, but I would like to see a full breakdown of the ownership in this proposed spacing. Or proposed unit, excuse me.
Okay. Mr. Robb? Can you provide that?
I can barely hear you, but I think you said, can you provide it? And yes, I can.
Sorry, my microphone was off. Mr. Robb, you heard what Mr. McClure is asking for. Can you provide that?
Yes, I can.
How long will it take for you to provide it?
I can put it together pretty quickly. I have it all in an Excel sheet.
Okay. Can you give me a time when you can have it ready?
I can have it by the end of the week, by tomorrow.
That would be the filing deadline for Ms. Hardy. So, Ms. Hardy, are you able to file that supplemental exhibit by Friday, close of business?
Yes, that's fine.
Okay, perfect. Then we'll leave the record open in this case for that information. And then we'll take it under advisement once we receive it,
Thank you.
as long as it's by tomorrow at 5 p.m.
Understood.
Okay, very good. Thank you, Mr. Rob.
Yes, sir.
Okay, moving on. Now it looks like we have 4 cases that are joined. These are 20 through 23 on our docket. 253, 84, 85, 86, and 87, all Mewborn Oil.
Again, Mr. Examiner, Dana Hardy with Hardy McLean from Mewborn Oil Company, and there are no other parties.
Perfect. Go right ahead.
Actually, I wanted to point out the spreadsheet does list Hardy McLean as representing Permian Resources, but that is an error.
Okay.
Yes, it's not
Thank you.
correct.
So you're not representing?
No. Yeah, no.
Thank you.
In these cases, Mewborn seeks to pool the Bone Spring Formation underlying sections 27 and 34, Township 23 South, Range 28 East, and will dedicate the units to the Yardbirds 2734 fee wells. Our exhibit packets include the self-affirmed statements of landman Mitch Robb and geologist Tyler Hill, again, both of whom have previously testified and been recognized as experts. Mr. Robb's land exhibits include the plat of tracts, ownership interest, and pooled parties in Exhibit A3. And again, in these cases, Mewborn owns between 94 to 98% of the interest, so is pooling a minimal number of parties. Mr. Hill provides the standard geology exhibits, including a location map, structure map, and cross-section. Exhibit C is our notice information and shows that notice was timely sent by certified mail on May 7th and 8th of 2025 and was timely published on May 15th of 2025. With that, I request that the exhibits be admitted and that the cases be taken under advisement. Thank you.
Without objection. Mr. McClure?
Mr. Hearing Examiner, I have the questions for Mr. Robb as well for these cases.
Perfect. Go right ahead.
Mr. Robb, on your breakdown of interests, do these exhibit packets also include a role listed as Mewborn et al.?
Yes, they do.
And does that include more persons than just Mewborn?
Yes, it does.
Again, will you be able to, if I were to ask you, if you understand what I'm asking for, if I want to see an entire breakdown of the ownership in this proposed unit, do you understand what I'm asking for?
Yes, and I can have that provided by tomorrow.
Okay, thank you, Mr. Robb. Thank you, Mr. Hearing Examiner. No further questions.
So thank you. So Ms. Hardy, same for these cases as well, deadline. The record will stay open until tomorrow at 5 p.m. And then we will take the cases under advisement. Thank you for your presentation. We're skipping over the cases we called earlier, and we're going on to number 29 on the docket, PBEX Operations 25394. And should of appearance, please.
Mr. Examiner, Jennifer Bradfute with Bradfute Sayer on behalf of the applicant.
Are there any other parties that you know of?
Yes, Mr. Examiner. Carrie Hatley entering an appearance on behalf of COG Operating, Concho Oil and Gas, and Mongoose Minerals.
Monitoring.
Monitoring only. Thank you, sir.
Ms. Bradford.
Mr. Hearing Examiner, in this case, PBX Operations LLC is seeking approval of an overlapping spacing unit, and it's seeking to pool a standard 480-acre, more or less, spacing unit covering the Bone Spring Formation, involving the Lusk Bone Spring North Pool code 41450. This unit is going to be located in the southeast of Section 31 and the south half of Section 32 in Township 18 South, Range 32 East in Lee County, New Mexico. And it's going to be dedicated to PBX's Dr. Vogel Southeast 32-31 wells. Attached in the exhibit packet are the typical exhibits A through C. Exhibit A is the affidavit by PBEX's landman, Ruth Pelzel, and the attached land exhibits that typically come in your uncontested application packet.
Ms. Bradford, has the Has your landman been accepted as an expert in that field?
Yes,
Thanks.
yes. And actually, I was going to state that at the end about both witnesses. Exhibit B is the standard packet from the geologist, Matt Parody, and Matt has previously testified and been accepted. Exhibit C is the typical notice exhibit. Notice was mailed May 15th, which is timely, and published May 21st, which is timely.
Thank you, Ms. Bradfield.
Yeah.
Are there any objections to the exhibits? Okay, without objection, Mr. McClure.
Mr. Hearing Examiner, I don't think I'll need any questions. I think I can just provide guidance to Ms. Bradford.
Go right ahead.
Thank you, Mr. Hearing Examiner. Ms. Bradford, it appears based off the written testimony that PBEX is requesting supervision rates during the drilling and operation of these wells. Is that correct?
That is correct.
Okay. On the CPAC, however, you don't have it directly listed. Do you know where I'm referencing on that?
Are you looking at the pooling checklist where it's not listed? It is listed in one of the exhibits.
That's correct. And in the compulsory pooling administrative checklist, or application checklist, I guess, there's a area where it says AFE, CapEx, and operating costs. Do you see where I'm referring to?
Yes, I do.
And here you're referencing Exhibit A. You also see what I'm referring to there?
Yes.
Okay, please amend that to actually include the rates themselves there rather than a link or reference to an exhibit.
Okay. Yeah, absolutely. We can have that filed later today.
Good, perfect. So we'll leave the record open until close of business tomorrow. And then we'll take this case under advisement as long as you provide that by tomorrow, 5 p.m.
Okay, thank you.
Thank you. Let's move on to Permian Resources. These are 4 cases that are joined together. They are 25395, 96, 97, and 98. And show appearance, please.
Yes, Jackie McLean with Hardy McLean on behalf of Permian Resources.
Thank you.
And there are no other entries of appearance in this case.
Thank you.
In case numbers 25395 through 25398, Permian Resources seeks to pool all uncommitted interests in the Bone Spring Formation within sections 4, 9, and 16, Township 22 South, Range 35 East, and Lee County. And these units will be dedicated to the Hagberry 4 State Com wells. Permian Resources submitted timely exhibit packets for these cases, which include the land testimony and corresponding exhibits from Travis Maka, and geology testimony and exhibits from Christopher Ruddle-Huber. Both Mr. Maka and Mr. Ruddle-Huber have previously testified before the division. Permian Resources also submitted notice exhibits, which include a copy of the notice letter that was sent out on May 8th, 2025, and the affidavit of publication, which shows that notice was published on May 13th, 2025. And I'm happy to answer any questions and ask that the exhibits submitted for case numbers 25395 through 25398 be admitted into record and that the cases be taken under advisement.
Without exception, Mr. McClure.
No questions, Mr. Hearing Examiner.
All taken under advisement. Thank you. And our final case of the day, number 34, is case number 25406, WPX Energy.
Good afternoon, Mr. Hearing Examiner. Good afternoon, Technical Examiner. Darren Savage with Aberdeen and Schill appearing on behalf of applicant WPX Energy Permian LLC, and we have no other entries.
Please.
So in this case covers lands in the east half of section 33 and 28 and the southeast quarter of section 21, all in township 26 South, range 30 East, Eddy County, New Mexico. The landman, Tim Prout, has testified previously before the division, and his credentials have been accepted as an expert witness, as well as has the geologist, Russell Gooden, who has also previously testified and has been admitted as a expert witness. In this case, WPX seeks an order pooling all uncommitted interest in the Bone Spring Formation designated as an oil pool, underlying a standard 609.58 acres spacing unit, more or less, comprised of the east half of sections 33 and 28 and the southeast quarter of section 21. The unit will be dedicated to the Clawhammer Fed Com wells, which include 4 initial wells, Orientation of the wells are stand up and the wells have standard locations. Mr. Prout's Exhibit A includes all the usual landman exhibits, self-affirmative statement, C-102, ownership breakdown, well proposal letter, AFEs, and the chronology of contacts. And Mr. Gooden's Exhibit B for this case includes the standard suite of 5 geology exhibits. Exhibit C provides the self-affirmed statement of notice for mailings and publication notice. Notice was timely mailed on May 15th, 2025, and timely published on May 20th, 2025. Mr. Hearing Examiner, at this time I move that Exhibits A, B, and C and all sub-exhibits be admitted into the record for this case and the case be taken under advisement. Witnesses and counsel are available for questions.
Thank you. Without exception, Mr. McClure, any questions for this case?
Mr. Hearing Examiner, I do not have any questions for this case.
And this case is taken under advisement. That concludes our business today. Oops.
No,
Ms. Vance.
yes,
We're coming back.
we're coming back.
To that one case from earlier.
Actually 3 matters. So I've got confirmation on availability for dates, and then I would like to present the last case.
The case, was it 25409?
Correct.
All right. So let's first deal with your witness availability.
Okay, so it would be for the 2 Oxy cases, which are case 25222 and 25225. And we are available August 13th. I had follow-up from Ms. Chance that it was not August 12th, but August 13th. But just want to confirm we're available for that hearing date.
Ms. Chance? Okay, perfect. So we'll issue a pre-hearing order for August 13th. And is August 13th a trailing docket? Okay, well, we have time to do that, it sounds like. Do you know what party is on the 12th that will have to move to the 13th? They may be in the room. I had a feeling it would be. Do you know which case it is?
We are a party in that case, but I think the applicant is represented by Ms. Shaheen.
Okay. Are you an objecting party?
We are not an objecting party, but there is an objecting party. I just can't remember who it is. I represent Red River Operating and they're monitoring.
Okay, perfect. Thank you. Oh, it might be you. Okay, so Ms. Chance, you'll notify Ms. Shaheen that we're moving the case to the 13th? Okay, sounds good. Okay, excellent. So we know that your first 2 cases will be heard on a trailing docket on August 13th. Okay, what else did you want to tell us?
Yes, and just to confirm, that is, I'm filing on behalf of EOG applications that are competing with Pride Energy's cases on August 12th. So noted on my part that we'll need to file for August 13th for those.
Perfect. Now I thought you just said that you'll be filing competing applications?
We are,
Okay.
will be, yes, and we stated that at the last status conference.
And they'll be filed in time to deal with notice?
Correct.
Okay, good. Okay, please proceed.
Well, I also want to address the 4 cases, case numbers 25388, 25390, 25391, and 25393. We are good for July 15th.
Perfect. Then we will issue a pre-hearing order for July 15th.
Correct.
In those cases.
All right, and I will go ahead with our last case here. So case number 25409, Matador seeks an order to approve a non-standard spacing unit. It is a 983.65 acre, more or less, non-standard horizontal well spacing unit. And this is in the Pennsylvania formation, and that's underlying the west half of section 26 and 35, township 15 South, range 36 East, and then lots 3 through 6 and lots 11 through 14, which would be the northwest quarter equivalent of Section 5, Township 16 South, Range 37 East, and that's Lee County, in pooling the interests in that subject acreage, and then dedicating that to, give me one second, the Steve Rochelle Statecom initial wells, the 241H and the 252H. And we have included in our hearing packet a copy of the application and the CPAC, as well as the statements of landman Addison Costley and geologist Joshua Burris, both of whom have previously testified before the division, and their credentials have been accepted as a matter of record. In Mr. Costley's statement, we did provide a paragraph of explaining why we're requesting the non-standard spacing unit. I would note in Mr. Burris's statement, I think it's duplicated in the hearing packet. So they're both the same. It just happened to get in there twice. We've included all of the other standard sub-exhibits for both of our experts. And then we've included a self-affirmed statement of notice with a sample letter that was timely mailed on May 16th, 2025. And then a affidavit of notice of publication, which was timely on May 21st, 2025. I should have both of our experts available for any questions, but I would ask that the exhibits and sub-exhibits be admitted into the record at this time.
Without exception. Mr. McClure?
Mr. Hearing Examiner, I'll have questions for both the landman and the geologist.
Okay, let's get them sworn in. Would you call their, oh, there we go.
Yeah, I think that they're there.
Oh, they're together. Okay, very good. Okay, I see two people on my screen. Not sure who's who. Would you state and spell your names one at a time for the record?
Addison Costley.
But you have to spell your name.
Oh, Addison Costley. Addison is Addison. Costley, Costley.
Okay.
Joshua Burris, Joshua
Okay, would you both raise your right hands, please? Do you swear or affirm under penalty of perjury that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes.
All right. Now, let's start with you, Mr. Burris. Ms. Vance stated that you have previously been qualified as an expert before this division. In what field is that?
Petroleum geology.
Petroleum geology. Okay. Mr. McClure, would you start with the petroleum geology questions?
Oh, yeah, I certainly can.
Thank you.
Mr. Burr, if I can direct your attention to your cross section in Exhibit D3, page 53 of 74. Are you with me, Mr. Burr?
Yes, sir.
Yeah, on this cross section, it appears that you have the Pennsylvanian top and the Pennsylvanian base identified, but none of the formations within the Pennsylvanian. Is that correct?
That is correct.
Okay. Where on this cross section, where would the base of the Cisco be located?
The base of the Cisco would approximately be 11,000 feet across a majority of these wells, where we go from generally the cleaner gamma ray signature being in the white on the far left track into what would be a higher gamma ray, darker colors below approximately 11,000 feet in a majority of the wells shown in the cross section.
Okay, and that's about at the top of your highlighted target interval. Would that be about correct then?
Yes.
Okay. On On this cross section, about where would be the base of the canyon at?
The base of the canyon would approximately be at 11,500 feet. I'm referencing in particular that the second well in the cross section, the Dean State 1, kind of again going from cleaner carbonate, generally gamma ray response being in the more white response below that, and then above going into kind of more of the black and darker gray, typically shale response of our target. And that would be the base of that canyon or the top of the Strawn as we interpret it.
Okay, and this essentially then would be the base of your highlighted target interval is about where it's at then, is that correct?
Yes.
Okay, and I guess let me rephrase that. I said about. Is it accurate to say that your target interval is above the base of the canyon across this entire cross section?
The target interval is above the base of the canyon in this cross section interval, yes.
Okay. Oh, go ahead, sir.
I'm sorry. It does include the canyon as we interpret it internally.
Okay, so just to confirm what I think you just said, and then your answers from the previous responses, then would it be accurate to say that the target interval here essentially is the canyon formation then?
The canyon formation is a portion, yes, of our target, yeah.
Well, of what's highlighted here in yellow. Is that
Yes,
the
sir.
canyon formation?
Yes, sir.
Okay. I have no further questions for Mr. Burr.
Okay, can we have the other witness on the camera now? Okay, so Ms. Vance said that you had already been qualified as an expert before this division, and I ask you in what field that is?
Petroleum land management.
Okay, perfect.
Yes, sir.
Mr. McClure?
Thank you, Mr. Hearing Examiner. Mr. Costley, not asking about the target interval of where the wells are going to be drilled. I'm asking specifically about what interval Matador is asking to force pull.
The Penn Shale formation.
Okay, in terms of Cisco, Canyon, Strawn, Atoga, Morrill, which of those formations those would make up the entirety of the Pennsylvanian? Which of those formations, what part of the Pennsylvanian, or is it all of the Pennsylvanian that Matador's asking to force pull?
I would say the portion of the canyon and north of the Strawn formation, north of the Murrow formation, but south of the Wolf Camp.
And by north and south, you're referring to above and below?
Correct. So above the Strawn, the Morrow, including parts of the canyon, and south or below the Wolf Camp.
Okay, very good, very good. Can I draw your attention to your summary of contact?
Yes, sir.
I think it might be Exhibit C6, but I think it's labeled A6. But regardless, it's on page 42 of 74.
Yes, sir.
On this summary of contacts, is there any indication as to like when these different events occurred?
Correct. So when we initially sent out the initial well proposals on March 6th, we sent them, through the mail, USPS, and so certain packages were delivered at different times, and so we received confirmation of delivery at different times between the initial sending and today. When those packages were, or through our online service, whether they were either categorized as delivered or returned. From that point, we participated in a due diligence effort to find a secondary address, through various sources online or other sources in the courthouse. From those sources, we attempted to send a copy to a different address in those owners. And so that's what the third column on the right represents, a second attempt through the mail. If there is a check there, then we attempted to deliver. And then the last column on the right shows if we have had additional conversations either through email or by phone, regardless of whether the package was delivered or if it was. Some of the parties maybe did not receive a physical package through the mail on the first attempt, but I was able to reach them via phone or email and have conversations and submit those materials to them kind of through those measures.
Okay, now as far as those, I guess the first three columns, is there reference to that in your statement? I'm looking through it now. For some reason I thought I'd seen it somewhere and now I'm not seeing it again.
Paragraph 13.
Oh, there we go. Yeah, thank you, Ms. Vance. And it does briefly discuss it, but we don't include any dates. Does it talk about anywhere at all in regards to a breakdown of that fourth column? Is that included anywhere in your exhibit packet?
No, sir. Just the sheer volume of parties. We did not include that breakdown of conversations with those parties.
I guess regardless of the volume, if I were to request a summary of the assorted communications, would you understand what I'm asking for?
Yes, sir. And I could provide that information to you if you request it.
Mr. Hearing Examiner, I don't have any more questions, but I do have some requests for Ms. Vance.
Go right ahead.